Everyone loves to get paid.
I think for most people, getting the judgment is initially a lot of solace. But then when they don't get paid because they didn't understand the judgments aren't checks, it becomes more salt in the wound because now this guy is getting away with it. Hey, everybody. Welcome to An Attorney and an Accountant Walk Into a Bar. I'm John. I'm the attorney, and my buddy here.
I'm Kent, and I'm the accountant. And today we're talking about enforcing a judgment. Pause. And then we're going to talk about winning cases, John. So let's talk about winning some cases, John. You know, when you win a case, they say it's kind of like scoring a touchdown, but leaving the points on the field.
Well, I think what you're referring to is the fact that 74% of judgments that are handed down in California are uncollected in the first year, which tells me there's a lot of people that are wasting money litigating and not getting paid.
Yeah.
Which is, to me, a horrible tragedy. So one of the things that we specialize in is collecting judgments that are difficult to collect. And I'm not talking about consumer judgments here. I don't mean like, going after someone's credit card debt or going after, some poor family and trying to take their house or anything like that. What I'm talking about is in business litigation, entrepreneurs and sophisticated business people oftentimes hide their assets. And people who typically do that are also typically bad actors. So you get into a business arrangement with someone, you get into a real estate contract with someone, they screw you over, you litigate it, and then you get a judgment and no one knows what to do with it. And I think that's one of the big weaknesses in my profession is that a lot of attorneys are excellent litigators. They know how to get a judgment. They get the judgment, and then they think they're done. It's like, I quit. Here's your judgment. And the client's there going, no, I don't want the judgment. I want a check.
Yeah. And that's kind of where I've seen your team really do a spectacular job. We actually work with a lot of attorneys. Some of our referrals come from that source, where we have excellent litigators out there. Not that your litigation team isn't top notch, but the specialty that is taking it that last mile. And going back to my same reference, but remember the old Jerry Maguire movie, Cuba Gooding Jr. goes, "Show me the money."
Well, that's the whole point of this, right? So what is a judgment other than a piece of paper with the judge's signature on it? And I think most attorneys know basic things like, I'll record the judgment where I think there's real estate, or, I'll bring him in on a judgment debtor exam, that sort of thing. But there's a real specialty to difficult judgments to collect, or what we call hard collections, where someone's hidden their assets or is a very wily business person and keeps their money in other people's names and keeps it here or there. And, they use Nevada corporations and all sorts of things and all sorts of layers. And peeling that back is where your team comes in and helps us, is doing forensic accounting, subpoenaing the financial records, subpoenaing phone records, subpoenaing corporate records, and combing through those and looking at transactions and tracing the money and finding out, where it goes. Like one of the cases we just worked on very recently, the gentleman who had basically absconded with millions of dollars out of a project and was squirreling it away in a 401k that he had in another state, and thinking that, retirement funds are often exempt from judgments, which is true. They often are. Not always, but they often are. But the thing was, he was way exceeding the contributions that he was allowed under IRS rules, and therefore that wasn't really retirement funds at all.
Sure.
And it made me wonder how it was that the institution allowed that, but apparently he had an in with some kind of financial planner that was letting him do that.
And overfunding investments is not necessarily a red flag in general. Sometimes people misalign that. It happens a lot, for example, like a Roth. People don't understand their income limitations and they end up overfunding. So that in and of itself, but in conjunction with things that your team are investigating, goes to an accounting principle where I always think that legal victory does not equal financial realization. And there's a big accounting distinction between the legal victory and then the financial realization. It can actually have a long-term impact on the business itself when you can actually realize things like bad debt, or when you have, on the flip side, revenue recognition for some of the losses that people have taken based on whether they expect to collect. So in conjunction with the forensic accounting, it could potentially help the income statement and or the balance sheet of an entity to get resolution after judgment. Because just because judgment happens doesn't mean I go to the books and all of a sudden recognize income, right? Because they don't have a check in hand.
Yep, exactly. Well, I think one of the things that's important to understand too is it takes a fox to catch a fox, or some people would say a thief to catch a thief.
Yeah.
And one of the things that I did early in my career, and I still do, is help wealthy individuals protect assets.
Yeah.
And there's a right way to do it and a wrong way to do it.
Yeah.
And I know I'm familiar with both. So I know where to look. I know which stones to uncover to penetrate these various vehicles that people create. Now, if they do something like an irrevocable trust and it's a legitimate irrevocable trust and it wasn't funded fraudulently because it was funded, well before the litigation or well before there was a debt, or, it wasn't done with intent to defraud creditors, those can be really hard to penetrate. But people don't like to do those because they lose control of the money. Yeah. If it's a legitimate irrevocable trust, they don't have any control of the money at all. It's not theirs anymore, period. Most fraudsters don't do that. They want to get their money. So they have little strings that they put into it. And if you can find those strings, you can penetrate that trust because you can prove that there was a control coming back. And therefore, it was no longer this impenetrable fortress. So there's ways to penetrate things like that. But mostly it's just finding the money, finding where they've hidden it. Do they have a Nevada corporation where they've hidden it? Looking at his payments, like, why is this, odd Nevada corporation getting $100,000 a month? What did they do for that? Where's the invoicing to back that up? Oh, who owns that corporation? Well, let's subpoena the bank records for that corporation. And you find out, the judgment debtor's got a credit card that he's been running around with, buying all of his stuff and buying himself houses and cars out of this corporation. And of course, those are very easily penetrated, but you have to find it and you have to know where to look. And that's, I think, what a lot of attorneys don't focus on because they're focused on getting a judgment. What are the causes of action, putting on the evidence, having a trial. Yeah. And they're good at it oftentimes. Yeah. And I'm shocked at oftentimes how really, really good trial attorneys and excellent litigators get the judgment. They're like, now what? Yeah. And a lot of it, you have to understand too, a lot of collecting judgments starts in the litigation, because one of the things you should focus on, and what I like to focus on, is, okay, we got this great case. How are we getting paid? Oh, well, there's an insurance company. Great. That answers it. Well, that's usually not the case in business litigation. There's usually isn't insurance that's going to cover, breaches of contract and fraud and that sort of thing. Insurance just doesn't cover those things. So then you have to look at, well, who are we suing? What assets do they have? Where have they hidden their assets? Well, it doesn't look like they've got much, that's the big thing defendants love to do is they play poor. I don't have any money. Look at me. I'm broke. I spent my last dime. Right. Well, first question I ask is, well, then why haven't you filed bankruptcy? Sure. Well, probably the answer is because they do have money. They've just hidden it. And they know better. Most people would know better, especially if they go to a good bankruptcy attorney. You don't mess around with the bankruptcy trustee. Sure. If you've hidden assets and you think you're going to go file bankruptcy, they will crucify you. And boo. And they are powerful. People do not appreciate how powerful the bankruptcy trustee is. So someone who's hidden assets is typically going to avoid bankruptcy, take the litigation all the way to the end, and then just, play poor. Well, you have to do financial discovery during the litigation to the extent that you can to get a hold of the business records and things like that, so you can at least have some feeling during the litigation that you're going to be able to collect this thing.
Yeah.
Because otherwise you're just wasting your client's money.
That's right. I mean, a lot of clients we advise, we have to integrate or advise them and let them understand that the judgment was one part of it. But if they have to go into collections can be a separate battle in and of itself.
Oh, absolutely.
You know, you're under,
and it can take years.
Exactly. But it's really where, as they say, the rubber meets the road, because that's where the value of spend potentially gives you a yield of actual dollars, you know, because the success of litigation in judgment collection means money. And it's not always 100%, but sometimes if you have $1 million judgment and you spent a lot on the litigation fees just to win, and then there's no money to show, at least if you're getting 80%, even 50% of what is outstanding on $1 million, you have $500,000 that came in. And there's also this, I have to say with our clients, just sometimes it's the level of satisfaction and justification that they put it to, a garnishment check coming in the mail, you know, knowing that the individual has been put the screws to. It can be very satisfying.
So there are a lot of reasons that people litigate. You think it's about money, and sometimes it is. More often than not, someone's been hurt or pissed off, and they see litigation as a way to vindicate themselves or cause pain to someone who's caused them pain, punished in some way. Now, if the client's got boatloads of money to do that with, and they can afford to spend hundreds of thousands of dollars litigating to make a point, I love those clients. That's awesome.
Yeah.
Let's do it. As long as we know that's what we're doing.
Yeah.
But I think most clients really just want to get their money back. I think that's what most people are trying to do is they got screwed. They lost money in a deal. Someone, did something to them that caused them injury, and they need to be remunerated for that because they don't have a lot of money. And when you have a client like that, you really have to explore with them what it's going to take to do this. And more importantly, can we collect this judgment?
Yeah.
And when you look at 74% of judgments going uncollected, that means there's a whole lot of litigation going on out there where people are spending tons of money and not getting paid.
And it's fruitless.
And I highly doubt that more than 5 or 10% of those are people that are just out for blood.
Yeah, no, that's true.
I think it's people that legitimately think this attorney's going to help me and he's going to get my judgment. And that means the judge is going to make him pay.
Right.
It's like, no, a judgment isn't a check.
Yeah.
The judge isn't going to make him pay.
Mm-hmm.
If he doesn't have the money or you can't get at the money, you ain't got shit.
Mm-hmm.
That's the truth of it.
So we always want to give our listeners the mechanisms and the information to have, I think, at least educated conversations with their professionals. And we should want to discuss later in this topic here about when it is the time to go to a professional for this, like a firm like ours, or whether there's something they can do on their own. So let's start with just on the legal side, and I'll add in the color for accounting. What all this does is just the general enforcement mechanisms, just the big picture things starting there, where I think you had mentioned liens. I just mentioned wage garnishment. There is bank levies, and there's a few probably other larger mechanisms that we can.
Yeah, I mean, this is a bit of a chess game when it comes to this because you have to consider a lot of different moving parts. You don't always want to go straight for a garnishment or straight for this or straight for that because you have to be strategic about what it is that you're doing. So the first thing you do when you get a judgment, in most cases, is get your liens in order, which means recording abstracts of judgment in every county that there's the remotest possibility that this person owns property. Every place they've ever lived, every place they've got family, you record your judgment there.
Sure.
You get an abstract of judgment, you record it. I would say 90% of attorneys know that, and they'll do that for you. And then they don't know what to do after that.
Mm-hmm.
I would say half the time, they don't record a UCC1 lien.
Oh.
Which puts a lien on all their personal property in the state. That's a pretty cool thing.
Yeah.
Automatic lien on all their bank accounts, on their any automobiles they have, any personal property they've got anywhere in the state. I get judgments all the time where I'm asked to help collect after some other attorney's gotten the judgment. I'm like, did they file a UCC1? No.
Yeah.
I'm scratching my head going, okay. Let's start with that.
Yeah. Yeah.
And then I think, now, if you already know where the assets are, all right, just go attach them. That's easy.
Sure.
A lot of attorneys don't even know how to do that, but garnishing wages is one.
Sure.
That's usually fairly fruitless, though, to be honest, because, the judgment debtor gets to cry poor to the judge and say, hey, I only make $10,000 a month and I got $5,000 in rent and I need, $2,000 for groceries and I got to get my hair cut and I got to buy dog food and the judge is going to look at it and go, well, I'm going to give you 20% of his wages, which is like dick, right?
Yeah.
Usually, you get like a check for a couple $100 every month. Well, that's not very helpful. It's probably not even worth the trouble to garnish the wages.
Sure.
So, but that's one. Another one is levies. So if we can find bank accounts, if you know where they are, slap a levy on them, man, and the bank will just take the money. Take it right out of the account.
If you can find it.
If you can find it.
Yeah.
That's the critical thing.
Yeah.
And, it's typically not going to be someone's checking account.
Yeah.
And someone who's allowed a judgment to be entered against them because either they didn't fight hard enough or because they just plain lost and didn't settle, they're not planning on paying you.
Yeah.
They're planning on absconding in some way,
Sure.
right? So they're going to hide their money. It's not going to be in their checking account. It's going to be in, the wife's checking account or the cousin's checking account. So you've got to get their financial records. You've got to comb through all their bank statements for the last 5 years and figure out, were these all, regular expenses and this guy was just living high, or was money going someplace consistently?
We've even seen a cause for safety deposit boxes where people have assets hidden.
Yeah.
But
there's ways to find those.
Mm-hmm.
You have to know the tricks.
That's right. Well, so let's talk about some of the common challenges. And one of the ones you mentioned, and what comes to mind, me as a layperson thinking about the nefariousness of folks, is there's one out, which you said typically they don't do. But what if they decide to file bankruptcy? What if they're like, well, bankrupt now?
There may be nothing you can do. If it's a legitimate bankruptcy and you're an unsecured creditor, there may be nothing you can do.
Mm-hmm.
But if you were litigating smartly, you would try to make your judgment bankruptcy proof. And you can do that by alleging and proving, you have to prove it, some kind of intentional bad act, we'll call it. There's a laundry list of things, but let's just say something they did that was intentionally wrong, like fraud.
Yeah.
Or, other kinds of malicious injury, intentional malicious injury. Example might be drunk driving.
Sure.
But a potential malicious potential injury could also be someone who was like a former employee who stole the computer from his employer and then was using the computer to contact the former employee's clients and try and steal them. Well, the act of stealing the computer can be shoehorned into making that judgment bankruptcy proof.
I see.
Okay.
Yeah.
Because there are non-dischargeable debts and debts that arise out of fraud or bad acts. So especially if you have like a case where, let's say, you don't think the other person's going to fight because they think they're judgment proof. So they think that you're going to sue them with a lawsuit and they're just going to give you the burden.
Sure.
Right. Okay. Why do they think they're judgment proof? You have to ask that question. Right. And if you think that's the case, let's put fraud in that lawsuit.
So when you talk
because if he's not going to defend it, we'll just get a default. And if we get a default, that judgment's going to say fraud on it.
So this goes into timing, and I want our listeners to understand timing, because one of the things you said is strategic litigation. So this happens prior to the judgment now, right?
Yeah, there's definitely things you do prior to the judgment. One is trying to make the case that the judgment you get bankruptcy proof.
Yeah.
Okay. The other is doing discovery during the litigation, if assuming the other side's participating, that is going to reveal to you something about their finances and something about where the money is.
Yeah.
And that can be tough to do because there's a lot of, privacy arguments that can be made and things like that. But if your attorney's good, he should be able to work around that stuff and find a reason that the judge needs to give us financial information. You may not get tax returns, but you're going to get bank accounts.
Sure.
Especially in business. You can always find some way to shoehorn the necessity for getting bank statements.
I mean, is it advisable even to think about enforcement during the case?
Absolutely.
Right?
Before you file.
So I think it's almost prudent. Sometimes if you have a great litigator and this litigation attorney is going to call it kick butt and take names, it might also be prudent to engage at the time of this, at the time of this litigation, a coordinating firm like ours to think about how to actually enforce it. So that way, during the case, you're bolstering the end result, which isn't just winning; it's actually getting a check cut, and finding it.
Yeah.
And I know we've worked with other firms in conjunction just to allow us to consult on that topic, so that way we can always enforce and actually try and collect on the behalf of our clients.
Yeah, and understand too, we're not talking about, I'm suing Eli Lilly,
right?
If you get a judgment against them, you're going to get paid, right?
Sure.
They're a publicly traded company. They're not going to be able to hide their assets from a judgment. But if you're litigating against my former business partner, Aram, Tangenerian, guess what? Aram's probably got his money hidden someplace. Maybe it's offshore. Maybe it's in his brother's trust. Maybe it's, gold bars in a safety deposit box. Who knows?
Yeah.
But those kind of slim shady guys, and they're usually the ones that rip you off. You can track them down. You just have to know what you're doing.
So what are some of the options of clients? So that you're talking about, obviously seeing the same or a different law firm to actually do the judgment collection. But on that end, we talk about outsourcing to professionals, because there's other options than going to legal firms. There's other options. Right. And I think one of those things is just essentially selling to a collection agency, depending on the type of.
Yeah, but collection agencies aren't going to be interested in buying your judgment if they don't see a easy way to collect it either. I mean, if the guy is playing poor and I've got no money, collection agency is going to not give you much money for that judgment.
Well, I think you might get, and then that's the trade-off, right? So sometimes if you think this is just too, or if a listener thinks it's just way too much and they're willing to take 40 cents or even 30 cents on the dollar, then perhaps that's
that's definitely a way to go, because if you can get even 30 or 40 cents on the dollar, you make it more money than chasing the guy around for 3 years and spending $100,000, $200,000 with a law firm to chase him around.
Yeah.
And then end up with even if you end up with the whole judgment, you only end up with 30 or 40 cents on the dollar.
In our consultations, we ask clients, and we're very practical in that, saying, what's the opportunity cost for pursuing this judgment? So let's say you have $100,000 judgment to enforce, but on average, you're spending $30,000 to $40,000 to enforce that judgment. Is it worth it after collection fees, and is it worth the pursuit? So time value of money of going into it. But sometimes, like you said, there's more than just the money.
Oh yeah.
There's more than just the money.
It's almost always more than just.
So if you end up collecting 60 out of the 100, but other person got what's called their karma or their just deserves, then we'll call it money well spent.
Fair enough.
Right? Teaching lessons in life.
Fair enough.
Right? Sometimes you say building character.
I think what I like to do for my clients is get their money and their revenge. Let's do both.
Yeah. No, we love that answer to the pie, and just giving our clients but they need to be prepared to buckle down. Like I said, it's an entire new undertaking to go that. Sometimes we have to unwind and break it back down, especially if I get involved and we start looking at forensic accounting, the process of asset tracing and looking at fraudulent conveyance, taking a look at not just financials, bank records, tracing the money, tracing actually sometimes locational data for individuals, figuring out where they spend a lot of time, and then piecing together a storyline of people that are living. And what makes it really interesting is that in the world of forensic accounting, it's really expanded with advent of AI and the fact that our world is much more digital than it used to be. When things are just cash transactions, money under the mattress, that's a rare occurrence right now. Your Apple paying at the farmer's market, for example, right? So the digital trail has made it more robust for accounting firms and law and the legal team to really work together in conjunction to find out what's going on, because it's going to be really, really difficult unless someone is extremely prudent about hiding their assets to actually do so in a digital world.
Yeah, I mean, and I think one of the things that is really exciting for us now that we're doing, and is very powerful, is using AI to analyze records to develop patterns and things that would just take untold hours. Like, for instance, getting phone records. You go through 5 years of phone records and you get a bunch of lists of phone numbers. Mm-hmm. What if you could find out where all those phone numbers went and see if some of them's going to a banker someplace, or an investment advisor someplace? And then you see, well, there's, 14 calls a month to an investment advisor. You never would have found that, where the AI will find it. Yeah. AI can do that kind of analysis, which is really, really powerful.
Just looking through some notes here. A lot of my accounting notes are really, and I want to bore our listeners with all the code sections, but it's talking about what happens if you don't get the money, right? If we try and we go through this, and what is the silver lining?
Yeah, can we write it off, Kent?
The answer is maybe. And the deductions are stringent because if it's personal judgment, it may be hard to actually take a loss on that unless it's the original transaction was from a income generating item, a business loan or some sort of income producing asset. But I loaned money to Joe Schmo, personal loan, IOU. I have to go after them. I don't. May not necessarily get the bad debt deduction on your personal return.
Even though you gave the guy money?
Yeah. So it depends
But you lost the money.
It depends on the nature of the transaction in and of itself. Yeah.
That's a terrible thing to find out.
So it's, or else all parents.
Shows you what I know about taxes.
Or else all parents would just say, listen, I loaned my kid all this cash for.
Well, what if it's like, I invest in a business?
Well, remember, like I said, business. Income producing asset. That's a business. You invested in a business.
I see. So it's what you put the money into.
Yeah.
I get it.
Yeah.
So if I lend money to a business,
it's an income producing.
Even if it's my friend.
Yeah. Business loaning is definitely part of it.
And then he doesn't pay me back. I can deduct that.
Yes.
What about all my attorney's fees I run up chasing it around?
So yes, it typically those are deductible by the person that's pursuing it. And but on the flip side, judgments necessarily that end up paying out aren't necessarily income recognition. Judgments received can also be typically income recognition to the person receiving it, because if we received the judgment of $1 million, at some point if they had a good accountant and it wasn't known they were going to get it, they might have deducted that.
Written it in the past.
So there's a double-edged sword to regaining that income. And sometimes we have a client that has a real estate deal that is going sour, right? And we're going to potentially litigate to recover. But in the interim, they also had a separate transaction of a large non-1031, right? Blow out of the 1031. So there's a huge gain that would be coming into this tax year. But serendipitously, there's this large loss coming in from this potential litigation, which we could substantiate, and you're going to offset. And in the interim period, while we're potentially litigating, it's not foreseeable that it could be collectible. And so therefore you have a fairly large offset. So instead of cutting a $3 million check, they may have to cut a $0 check currently. So it's a current tax benefit. In the future, the flip side of that is when it is recovered, there's a fairly large income stream coming in that year, in that tax year. And I wouldn't say to use arbitrage, but talking to a good tax professional will allow you to say, hey, this silver lining in the loss is that you don't have to cut a $3 million check. Right?
Well, that's some solace, I suppose.
Yeah.
I'd rather have not lost the money in the first place.
Yeah. So for our listeners to kind of think about it, it is, as long as the litigation and judgments tied to income producing activity, a business loan, something like that, those legal fees are deductible for, the plaintiffs, things like that. But if it is, you're lending money to your neighbor to like buy a lawnmower that he's not going to use for business, just for funsies, and you lose out, even the small claims, you don't really get much solace for that.
Well, what if, just out of curiosity, what if you're suing someone who's injured you in some way, caused property damage or physical injury, and you're then spending money to try and recoup that injury or that property damage? Is that deductible?
So personal injury is in an entirely different subsection. So we're talking typically just business income. Personal injury, if it's done correctly, for example, not too long ago, the Woosley fires, right? There's that kind of settlements that came out of it, and potentially the Palisade fires that happened recently in California. Any insurance payout, if it's done correctly, may not have to be recognized as income.
Right, because it's replacing an asset.
Yeah.
But what about if you're incurring attorney's fees to chase that?
Yes, those will be accrued. They're not deductible currently. I mean, they would be accrued. So the point you have, and this is where we talk about judgment, when you have a final say from the courts, then it becomes something called realizable. And in that, you can then look to take that deduction if it's applicable.
Okay.
So we talked about some other options outside the law, outside legal firms. So third-party collections. So have you ever had clients that took a look at, collection firms?
Oh, yeah. There's tons of firms out there that do collections. But honestly, that's typically consumer collections. So it's like credit cards, personal loans, things like that. Those kind of firms are very good at harassing people into paying if there's anything there to pay, and they're usually smaller amounts. Consumer collections is not what I'm talking about. What I'm talking about is big judgments, hundreds and hundreds of thousands of dollars, if not millions, and pursuing somebody relentlessly until, literally chasing them around until you find the money and take it from them, or make it clear to them that you're going to, if they don't come to the table with some bucks to make you go away. Most collection firms don't have those sorts of skills. They work in volume. They literally are working with thousands of judgments or thousands of debts that they're trying to collect.
Yeah.
And they make a little, vig on that is basically how they make their money. So it's a huge volume business, and you're never going to have the type of mind power to focus on the singular goal of getting this particular judgment collected.
Mm-hmm. So what can someone expect if they're talking to their legal counsel, their attorney, about what it takes to essentially start another battle, another litigation case in order to actually pursue a judgment?
Well, I think these are conversations that the client should be having with the attorney before they even file a lawsuit. Is, one, how are we going to collect this thing? What are we doing here? And answering that question, and then focusing, and if they do decide to go forward with litigation because they do think they're going to be able to collect, strategically planning the litigation to finding the pieces of information that you need during the litigation to be able to collect. And then finally, once the litigation is over, does the attorney have the skill to, ask the attorney, what are you going to do?
Sure.
What are you going to do? We get a judgment, then what? And he says, well, we'll file a lien and then, we'll have a lien on his property. If that's the answer you get, go the other way, or plan on hiring someone like me after you get done. to collect your judgment. So this is things that you should be asking. What are you going to do? And if you should be hearing things like, well, the guy's got real property, so we're going to file an abstracted judgment and we're going to record it, and that's going to give us a lien, and then we're going to sell the house. And this is the procedure we're going to use to sell the house. Most attorneys don't know this procedure.
Sure.
But there is a very particular, very difficult procedure to selling someone's house. And, and then they're going to be entitled to judgment exemptions. They're going to be entitled to homestead exemption. And this is what the house is worth. And this is what the liens are on it. And therefore we can expect to get paid X from the house. That's the kind of answers you should be getting. They should also be telling you, we'll file a lien on all their personal property. And then I'm going to bring him in on judgment debtor's exam. And I'm going to run a microscope up their ass on every single transaction, every dollar that they've spent over the last 5 years. And then we're going to do this and we're going to do that. And they better have, if they don't have those answers, then you're dealing with an attorney that doesn't know how to collect judgments.
Yeah, that's right. That's good advice.
Which doesn't mean they're a bad attorney.
Mm-hmm.
It doesn't mean you shouldn't hire them to be a litigator, because they could be a hell of a litigator. They could be a hell of a trial attorney. And believe it or not, that's a talent.
Absolutely.
Getting a big judgment is a skill.
Yeah.
That at trial, if it goes that far. And most attorneys aren't very good trial attorneys either. But so I'm not saying don't hire the guy. I'm just saying plan on, speaking frankly with him about, hey, do you have someone you can refer me to collect the judgment? Is there someone that that'll specialize in that? If that's not your jam, that's fine. But know that that's going to happen.
Yeah, and that goes into the bigger topic where sometimes when you say, if it's an Eli Lilly, that's easy.
Yeah, you don't have to answer the questions when it comes to them.
If a large corporation, I don't mean to pick on Eli Lilly, but any large corporation in general.
Or a publicly traded corporation, unless they're, 1 foot in the grave and the other in banana peel,
yeah,
they're going to pay.
And with that, there's the concept, because some clients will come over and they'll say, hey, I heard there's contingent fee arrangements versus, paying retainers and having you litigate. And so what would lead to that decision? Now, it's easy to say contingent fee if you have a $100 million judgment and you're going against a corporation with large assets, let's go for it.
Well, consider this. Most attorneys aren't going to take most cases on contingency.
Mm-hmm.
When will an attorney take a case on contingency? Well, there's two kinds. One is they're a street lawyer and they've got nothing else to do with their life and they're a complete bottom barrel scumbag, in which case they'll take a case on a contingency. But the reason that most attorneys, decent attorneys, are going to take a case on a contingency is because they know they're going to get paid.
Yeah.
They know there's a judgment there. They know there's insurance. They know that they're going after General Motors.
Yeah.
And we're going to get paid. And then the attorney's got dollar signs in his eyes and he's willing to take it on a contingency because he's going to get a lot more money. He's going to get a big piece of the judgment.
Sure.
If it's a $3 million judgment, he might get $1 million. Or if it goes to trial, he might get $1.5 million. He might get half the money.
Yeah.
Wow. That's pretty cool.
Yeah.
So yeah, if the attorney's excited about taking it on a contingency, well, one, ask yourself, can I afford to pay the guy?
Yeah.
In which case I'll save myself some money in the end. But also know that, hey, this attorney thinks he's going to get paid, which is good for me.
Yeah.
If an attorney's like, no, I'm not taking on a contingency, probably the reason is, I don't know who this guy is that we're suing. I don't know that he's going to have any money at the end of the day.
Yeah.
I don't know that he's not going to hide his assets.
Yeah.
And then end up chasing him around for the next 5 years. And I'm not on board with that. So what I want you to write me a check every month for my time.
Yeah.
And that's what I want. Because that attorney's uncertain about getting paid.
And even if there are a lot of strings to pull and investigate, that takes time. You have to be seated in for a patient and longer battle. So when it goes back to motivation, is it just to get any scraps of money? Or is there more to the reason for pursuing? And that the fire may have burned really hot at the time of litigation, but could winning the judgment be part of, the solace that happens? Now, everyone loves to get paid.
I think for most people, getting the judgment is initially a lot of solace. But then when they don't get paid because they didn't understand that judgments aren't checks,
It's more salt in the wound.
That it becomes more salt in the wound because now this guy is getting away with it.
Yeah.
I proved my point and he hasn't been punished.
Mm-hmm.
And that's a lot of the whole reason for the court system. I mean, if you think about the structure of the legal system, it can be argued that the reason for the legal system in a civilized society is to avoid people taking an eye for an eye.
Yeah.
So in the case of, say, for instance, a criminality case, well, you killed my daughter. In an uncivil society, I kill you and your whole family.
I see.
That's how we do justice, right? Well, because we have a civilized society, that person gets arrested and he's broken the law and the judge is going to punish him. The state's going to punish him for you. So the state's going to extract your revenge. And that's the same with the civil system in many cases, is it's a vehicle to extract revenge in a civilized way.
Yeah.
So that's a perfectly fair and valid reason to litigate.
Yeah.
Is if it's just to win and make a point that prove you were right and get your revenge.
Yeah.
And get vindication. That's better than you going and shooting the guy. Right?
Yeah.
So fair enough. Let's do that. But people need to understand that's what we're doing.
Yeah.
And that's what upsets me so much when I oftentimes get these cases is they didn't know that's what they were out for revenge. They wanted their money back because it was their life savings. It was their nest egg, and they got suckered by some dude, and now they want to get their money back. And in those cases, you have to be very careful about counseling the client and making sure that they understand, how is it we're going to collect the judgment and what's that going to take to do that.
A lot of times a client will approach, their tax accountant and say, I got this judgment. I said, you don't want me to book that as income because I take that judgment. That's what we said at the beginning. Judgment and financial resolution are two different things. And on the accounting side, I have clients come up and if you book that income, guess what? The IRS is going to want their tax.
Oh, of course.
On that recognition of income, whether you received it or not.
Get there.
Yeah, exactly. And don't pay them until it's necessary. And that's why you kind of say that, more of a closing thought is that a judgment isn't an asset until it's in the bank.
Yep.
And it's just a number on paper and definitely not your P&L. So do you have any closing thoughts for our clients who are seeking, judgment relief, I guess, or judgment pursuit?
I think that's really, to sum it up, is if you're going to get involved in litigation, understand for the most part it's a rich man's game. Really consider carefully how it is that you're going to get paid, because litigation is always going to cost you more than you think. Is always going to cost you more than the attorney says it's going to. And that doesn't mean the attorney's being an evil person. It's just how it is.
Yeah.
It's like building a house. There's unforeseen things. Because, in defense of attorneys, they don't know how hard the other side is going to fight. So
Correct.
You could come to me and say, well, John, what do you think that this is going to cost me? Well, if we do this and we do our discovery and we go take it to trials, it's a fairly simple case. And it should be 25, 30 grand. Okay. So we get into it and the other side comes unfrickin' glued and the guy's angry as hell and he hires an asshole lawyer ABC firm. And next thing I know, they're trying to take 50 frickin' depositions. Oh, now we're into hundreds of thousands. Yeah. Is that my fault? Not really.
Yeah.
But so it's really, so when a lawyer tells you how much something's going to cost and all the clients insist on knowing, he doesn't really know.
Yeah.
It could be a lot less. I've had cases that were a lot less where, hey, I had a case where we wrote a letter and got a check in a week for $300,000. It cost the client, $800 to get that money.
That was wild.
Great. And then I've also had cases where I thought would be simple and they thought would be simple. And then it turned into this emotional pissing match. And the case, ended up costing hundreds of thousands because it turned into World War III. So you really, when you get these kind of estimates from lawyers, They're doing their best most of the time to try and tell you, I just did a case like this and it cost 50 grand.
Yeah.
Does that mean your case is going to be 50 grand? No, it doesn't. It could be a lot more. It could be less.
So on the accounting side, we just got to think you never count on the money till it hits the account and you plan for the costs of going after it. So I think that's it for today's Attorney and Accountant. We'll walk into a bar. So just for our listeners to remember, you may have won in court, but if the money's still out there, the fight has just begun.
True enough.
All right. Thank you, everyone, for tuning in, listening. That's a wrap.